It's May 1st. I can't believe it's May. But today we are going to jump back in time. We're going to just hop in the TARDIS and all go together, or DeLorean, pick your nerd. We are going to go back in time and cover day 4 of the Karen Read trial from Friday, 4/25. It is a short day. It was a half day in court. It's the day they did the jury view. It was a pretty quick day with only 2 witnesses. We're going to take a look at those 2 witnesses together. We're going to hear as best we can what the attorneys had to say about the jury view. We can talk a little bit about what a jury view is or is not, and cover those 2 witnesses as we jump back in time. Day 3, we heard from Daniel Whitley from the Cannon Fire Department. We heard from the general manager of CF McCarthy's, the keeper of records for the Waterfall Bar and Grill, and then Mike Camerano. And then at the end of day 3, Trooper Garino came in and read those back and forth text messages between Karen Read and John O'Keefe, back and forth, where it was like, are you coming here? I don't know if I'm coming here. Are you coming over? But the water heater, those text messages. So that's what we're coming into now. So we know from the prosecution what they want the jury to take a look at. They want the jury to pay attention to the Lexus, to the right rear taillight, the height of the bumper, the height of the hatchback. The note that the visibility is different, I think, is obvious, but it felt necessary to point out these are local jurors. There's a reason there are local jurors. It's because they understand where they live. So telling them that the weather in April is different than the weather in January feels obvious, but they wanted to point out the visibility is different, the weather's different. Take a look at the flagpole, take a look at the fire hydrant, take a look at the Lexus, take a look at the height of the bumper and the height of the berm on the car. Just take a look. You will do a proper investigation is not really a proper opening because the jurors aren't allowed to investigate. They're only allowed to observe. I have not seen this jury. We will not see this jury. So this is all hyperbole from me. But if there was a juror that looked about 6'2", they can't look at the 6'2" juror and be like, oh, go stand by the Lexus. Let's see like where the Lexus squares up on your body. Go stand next to it. We're going to run a little experiment. Let's like roll down the lawn and see. They're allowed to observe. They're not allowed to investigate. And the defense made a few references to your investigation. I understand that it ties back into their opening. I think it was better placed in their opening when they say you will pay better attention to this case than the investigators did. But asking them to investigate is tenuous because you're almost inviting improper jury behavior. They can't investigate. They can't just grab their phone, go drive around and see if it registers steps. And they might be tempted to. Ending the opening with, you will do a proper investigation is rough.
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look, okay? Those are the instructions. We will see you in a few minutes.
She wouldn't have reread the instructions if Yannetti had said, we trust that you will observe 34 Fairview so you understand the testimony that comes in. That would have been completely fine. But saying and ending it with, we trust you'll do a proper investigation is rough. The first time he said investigation within these 4 walls. But the second time he said it, we trust you will do a proper investigation. I understand more and more why the court is so frustrated with the constant pushing of the line.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
Like her last words to him.
Yes.
Correct.
Okay.
Okay.
Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
There it is.
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she
Good
believed
questions for him.
he ever received her last words to him?
There's no other details than
Say that
there was no
again?
other details other than what
Those
she
are
said.
good. That's a good line of questioning.
But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay.
Interesting.
In your mind, did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voicemails? Did you put those two things together?
I didn't.
Okay. Thank you.
Her last thing that she had said to him was an argument. Did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection. Your Honor.
Sustained.
You then were interviewed, weren't you? Were you
Yes.
interviewed on February 14th, 2022?
Yes.
And you referred to the fact that she told you there was an argument earlier in the night?
Argument early in the night.
Okay. And she was telling you this when you were speaking to her that morning?
Correct. Around 6 a.m. Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No.
or midnight?
I didn't know the time.
His answer is he doesn't know.
You were asked on redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the night could have been 6 o'clock p.m.,
Early in the night. Yeah, correct.
could have been 5 o'clock p.m.,
Could have been.
could have been 7 o'clock p.m.
Sure.
Okay. You were also asked whether or not Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't.
That I remember. Correct.
But she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you. That's all.
Just two witnesses testified on day 4. We got into the paramedic partner of Dan Whitley, who was with him when he transported Karen Read to the ER on the Section 12. And we got into the foundation from Good Samaritan drawing Karen Read's blood after the jury view. I think the points that were really made on the first witness with regard to Good Samaritan is that the Good Samaritan Hospital lab is a medical lab, not a forensic lab. I know in the first trial, the defense brought a lot of points about the difference between the lab testing, the fact that the blood taken from Karen Read was not being tested for forensic purposes. It was being tested for treatment purposes. I have to wonder if in this trial, with the various clips of her that the jury's already seen where she's talking about drinking and driving, if it will matter that much, or if they are going to say, yes, she was drinking and driving that evening. We've heard her talk about it now, saying in clips things like, oh, I can see in the videos of me driving, I'm driving slowly, and that's how I drive when I drink and drive. And her talking about, well, the Commonwealth is saying I did 9 drinks, but it was really more like 6 drinks, and the drinks were really weak, so I was putting shots into the drinks because they were weak, and I didn't drink all of this shot, and I didn't do this and that. It's going to be interesting to see if the point about the blood draw matters as much now that we have those interviews that Karen Read did between the two trials, and even some of the interviews that weren't brought in at the last trial, but are being used now. I don't know if the difference between the medical lab and forensic lab will really matter to the jury all that much. Then we got to the paramedic. What stuck out to me in cross-examination is that Jackson was asking about Karen Read's last words or conversation with John O'Keefe and how this paramedic remembers what she said. Did she say she was upset because of her last words to the decedent, John O'Keefe, or was she upset because of her last conversation? I think it's a point that matters very much because last conversation could well be in the car at 34 Fairview, where last words could well be interpreted as the voicemails that are yet to come into evidence. And I think Jackson made a good point that I don't remember from the first trial, where he said, and when she was saying her last words, she was showing you how many missed calls were on her phone. And we know that Brennan was worried about this point because in redirect, that is what he was hammering in on, that Karen Read never said voicemails. She said their last conversation was an argument. It will be for the jury to decide how they interpret the paramedic's words, saying her last words to him, her last conversation with him, and seeming to use those a bit interchangeably as he was summarizing what he remembered. The reason he was asking Karen Read those questions is because of the Section 12. She had said to her father, if he doesn't live, I don't want to live. I'm not going to be able to take care of the kids. She said that part to paramedics as well. And they were inquiring about that before taking her on the Section 12 hold. And she said, essentially, I don't literally mean those words that I'm not going to live. There's not a plan, but I'm upset because our last words or conversation were an argument. And they were talking about an argument earlier in the evening. And Hank Brennan was saying earlier in the evening could be 12:30. And Jackson said earlier in the evening could be 6 p.m. because the jury has seen all the text messages between Karen Read earlier in the evening with John O'Keefe, going back and forth about the Facebook friending in the hot water heater and alluding to an argument they had had the night before that and had woken up in the morning and was still carrying over because they had not resolved the disagreements that they were having in their relationships that had spilled into the day of the 28th and then overnight into the 29th and the morning of the 29th. It will be up for the jury to decide. I think good points were made on the cross-examination, but the jury hasn't heard the voicemails yet. So will those points be remembered by the time we get there? Maybe. But I think they did a good job of pointing out that there are two interpretations of what Karen Read is saying to law enforcement. And remember, at the end of this case, we will get to the jury instruction that says, if there are two reasonable interpretations, you must pick the interpretation that leads to innocence. And that is one of the things when you have cases with circumstantial evidence, the jury gets to interpret what that evidence means, and the jury instructions tell them that that interpretation, if two are reasonable, must point towards innocence. And that is why we are seeing the arguments of both sides are going to continue to come up. And the interpretations of things two ways are going to continue to come up. You build the case towards your closing. And I think we're seeing both sides bring in the points. Like, you can almost, for me, see the bullet points that the attorneys are highlighting that they want to make in closing. And you can feel that today the defense was like, and I want to argue she was upset because she thought John O'Keefe heard the voicemails. That takeaway undercuts count 1 and count 3 significantly if the jury believes that part of the reason Karen Read is so upset the morning of the 29th when they find John O'Keefe is because she thinks he might have heard all of the voicemails that she left him and that those were her last words. The prosecution, of course, is going to argue that their last words were a fight in the vehicle at 34 Fairview. However, I also think it could be both. And I think we are going to see clips of interviews where Karen Read talks about the fact that they were having discourse at 34 Fairview about whether John was going into the house, whether he was going to come out and tell her if they were going to the party or not. And we haven't seen those clips to my memory yet, but we will, I think, see those clips of her talking about John going into 34 Fairview and her waiting and waiting outside. But then again, maybe we won't. That's my memory from watching some of the docuseries. So I think that might be where they're going. But we'll see if they choose to play that clip or not. Maybe they won't, because in that clip, she says that John O'Keefe goes into the house at 34 Fairview. So maybe the prosecution will choose to leave that out. And remember, the defense can't bring those clips in themselves. If they want Karen Read to talk about it, then they have to put Karen Read on the stand to explain, yeah, when I drove away from 34 Fairview, I was pissed because I was sitting outside in the car waiting for him to come back out of 34 Fairview, and he didn't. And I was mad, so I left, because the defense can't bring it in through the interviews. Maybe the prosecution will, maybe they won't. We're going to have to wait and see. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.